has publicized its view on hemp extracts in multiple forums, including through the public statements of its agency staff and representatives. So for example, in December of 2020, Sean Mitchell, chief of the DEA's Office of Intergovernmental Affairs, explained that according to the DEA, hemp processors in possession of substances such as IHM and WHM are not protected under federal law, and DEA retains discretion to enforce the Controlled Substances Act as to these extracts. When asked about the DEA's position regarding elevated levels of Delta-9 THC during CBD extraction, Mr. Mitchell responded that DEA retains discretion to enforce the Controlled Substances Act as to hemp byproducts such as IHM and WHM, adding, quote, "You'll never hear DEA say that we're not going to enforce any federal law." But of course, this statement only makes sense if Mr. Mitchell views IHM and WHM as legitimate targets for DEA enforcement under the CSA, Controlled Substances Act. Mr. Mitchell also asserted that hemp manufacturers or processors in possession of IHM or WHM should register with the DEA, and equated hemp processors with pharmaceutical companies that, quote, take non-controlled raw materials, but are nevertheless required to be registered with the DEA as a controlled substance manufacturer because they produce or manufacture controlled substances during the manufacturing of that not controlled end product. So through these statements, the DEA has mistakenly asserted its authority to impose criminal and or civil liability against unregistered hemp processors who manufacture or process IHM and WHM. Because of this threat, a group of hemp lawyers, along with the HIA, decided that legal action was necessary to protect the hemp industry at this crucial moment. That legal action is the subject of today's webinar. The law firms, which include Vicente Sederberg, Coban Law Group, and my firm, Kight Law Office, recruited the Yetter Coleman firm, which is nationally known and well respected for its litigation expertise with respect to federal agency actions. And in addition to the HIA, which is the only national hemp association to take a stand against the DEA's position, we're also fortunate to have my client, Re-Botanicals, as a party to the legal action. Re-Botanicals was founded by hemp pioneer John Rulak. Re-Botanicals also owns the Palmetto Harmony brand of hemp products founded by another hemp pioneer, Janelle Ralph. Both Janelle and the executive team at HIA have taken significant and active roles in the legal action. And as Shane will discuss in more detail, this is a complicated legal action. In fact, when I say legal action, that's actually shorthand for two completely separate legal actions or lawsuits that have been filed against the DEA. One was filed in the DC Circuit Court, the Court of Appeals, and the other in the DC District Court, which is just often referred to as the trial court. Now, before I go any further, and just to piggyback on what Jody said, I should note that legal action is currently pending. We are in the middle of these lawsuits. And for this reason, Shane and I cannot discuss any non-public information, nor can we discuss our strategy. In fact, we're assuming that the DEA will watch or maybe is currently watching this webinar. I mean, I know that I would certainly watch a DEA webinar on a pending case in which I was representing the opposing side. So in addition to not wanting to tip our hand to the DEA, things that members of the legal team say in public could be used in the court proceedings. And for these reasons, we'll provide certainly as much information as we can today while not prejudicing our case. So if we refuse to answer a question or if we answer in a way that doesn't seem complete, this is the reason why. So what I'm going to do is give a brief summary of the legal action, and then I'm going to pass the baton to Shane, and then we're going to take your questions and hopefully provide you some real good information going forward. So to start with, after discussion and analysis, the legal team decided that the legal actions were most appropriately brought before the federal courts in DC rather than in another jurisdiction. We first filed a petition with the U.S. Court of Appeals for the DC Circuit on September 18th, 2020. And that action, we, of course by we, I mean HIA and Re-Botanicals, claimed that the IFR is unlawful because it exceeds the DEA's legal authority and violates the 2018 FAR bill. We also contend that the DEA issued the IFR without observing procedures required by law. Agencies cannot just issue rules without proper authority or without following proper procedures. Congress removed hemp from the Controlled Substances Act, thereby removing it from the regulatory oversight of the DEA, which is the agency that enforces the Controlled Substances Act. Additionally, in the 2018 Farm Bill, Congress expressly gave regulatory oversight of hemp to both the USDA and the FDA. It did not grant the DEA oversight or authority over hemp. In short, the petition we filed with the DC Circuit Court of Appeals requests that the court hold the IFR unlawful and set it aside for three reasons. First, the DEA promulgated the IFR without observance of procedure required by law. Second, the IFR is in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. And three, the IFR is an agency action that's arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. Soon after filing the petition with the Court of Appeals, we asked the court to stay the legal action because we also filed a broad lawsuit against the DEA in the DC District Court on October 12th, 2020. We filed an amended complaint on January 21st, 2021. That amended complaint is 32 pages long. The amended complaint, importantly, does not seek to set aside the IFR like the petition in the Court of Appeals. That's what we asked the Court of Appeals to do. Rather, the complaint in the District Court goes into a lot of detail about the history of hemp, the current state of the industry, how hemp products are brought to market, including, and importantly, the processing stage in which IHM and WHM are present, and the DEA's ongoing efforts through the past several decades to derail hemp and exercise unlawful authority over it. As Jody mentioned, the HIA has a long history of fighting the DEA to protect hemp and the farmers and businesses that work with it. In fact, we call this Hemp 4. This is the fourth time the HIA has brought the DEA to court over hemp. In this lawsuit before the trial court, we request that the court do the following three things. First of all, we ask the court to declare that either A, the definition of hemp is set forth in the 2018 Farm Bill includes IHM and WHM, or two, regardless of whether IHM and WHM or hemp is set forth in the Farm Bill, the Farm Bill authorizes and or immunizes the possession and manufacture of IHM and WHM. Secondly, we ask the court to declare that the possession and manufacture of IHM and WHM during the hemp production process does not require registration under the Controlled Substances Act with the DEA. And three, we ask the court to enjoin the DEA, in other words, enter an injunction from enforcing the Controlled Substances Act as to IHM and WHM. Recently, and you probably saw this in the news, this second lawsuit, not the first one we filed in the DC court, but the suit that was filed in the DC trial court, the district court, was dismissed. Shane can explain this in more detail, but essentially the court found that our lawsuit was actually an action to set aside the IFR, which can only be heard by the Court of Appeals. We respect the court's decision, but we also respectfully disagree with its analysis and conclusion, since we did not seek to set aside the IFR in that particular lawsuit, but rather asked the court to enter rulings regarding IHM and WHM regardless of the IFR and based on the DEA's position on those extracts as stated in multiple media formats. We're contemplating an appeal of that ruling. Importantly, the case was dismissed without prejudice, and the court was careful only to address and rule on the procedural issues. It made no ruling on the substantive merits of our case. In other words, it did not opine on our position about IHM and WHM. Additionally, our case that seeks to set aside the IFR itself remains pending in the DC Court of Appeals action. So I'm going to wrap up and let Shane tell you more about the IFR, some important aspects of administrative law, and other items of importance. But I first want to mention two things. First of all, we have congressional support at the highest levels for our legal actions. As part of the trial court lawsuit, we received 2 letters from members of Congress who drafted the 2018 Farm Bill. They described the DEA's efforts to criminalize the intermediate steps of hemp processing as, quote, wholly inconsistent with Congress's clearly stated purpose and the text of the 2018 Farm Bill. Other members of Congress have emphasized that DEA's assertion of regulatory authority over hemp production, quote, ignores the clear legislative intent of the Farm Bill by making the processing of hemp extracts, derivatives, and cannabinoids subject to DEA enforcement as a violation of the Controlled Substances Act. I think it's really important to note that we're not out here without very strong congressional support from the very members of Congress who drafted the law itself. Second, and really importantly, these actions are crucial to the future of the hemp industry, and their outcome will almost certainly impact your business either indirectly or directly, and your support's needed. This support can take the form of financial resources, of course, but it can also take the form of networking to ensure that everyone that you interact with is aware of and educated about the IFR, the DEA's position in these lawsuits. And then finally, engaging with your members of Congress about the lawsuits and the issues they raise, to let your local members know that this is important to you and they have constituents in their districts that are following this and that deem it really important. So thank you again for having me here. I'm going to pass the baton to Shane. I look forward to hearing your concerns and to answering your questions.
Thanks, Rod. That covered a great deal of the important information. I just want to say that I also am happy to be here with everyone, and very grateful for the opportunity to chat with everybody, give this update, and answer any questions. Rod covered most of the basic facts, but I want to try to simplify the two lawsuits a little bit and explain why we brought two lawsuits and how they're different in just sort of plain language as I can. Ordinarily, when you're challenging a final decision of the DEA, like the IFR, you challenge it in a court of appeals. It goes straight to a court of appeals, and that's because a statute requires you to challenge them there. It says all final determinations of the Attorney General under this subchapter are subject to judicial review in the Court of Appeals, and it gives different options for which Court of Appeals you can proceed in. So the challenge to the IFR, which is a challenge to a DEA determination, that one under 877, this statute that I was just talking about, is routed to the DC Circuit. And so that's where we filed it. And that was the first thing we did when we decided to challenge the IFR. And before I go to the other lawsuit and kind of contrast it, I want to just talk about what your relief looks like if you win a petition for review challenging the IFR. If we were to win, the court would hold it unlawful and set it aside. And that would be great, and that would be very important. It would also be fairly limited, because it would mean that the DEA could come back behind that afterwards, after that ruling, and pass another rule or make some sort of new pronouncement that effectively tries to bootstrap itself back into the same unlawful territory that it's in now. And so in light of that, and because we don't really think that DEA's assertion of authority to regulate the manufacture and processing of and the manufacture and possession of IHM and WHM in the production process is even part of this subchapter of the Controlled Substances Act. It's not something that is even within the agency's purview at all. Our view was that we shouldn't have to keep going back over and over and over under 877 to the Court of Appeals to do these limited piecemeal challenges to every single DEA assertion of authority that's improper. In our view, the theory is and was the 2018 Farm Bill, not the CSA. The 2018 Farm Bill created established a new vision, a new regulatory scheme for these materials. And it said, here's what hemp is, and the production and processing of this stuff is subject to regulation by USDA and in some limited respects, the FDA, and did not include DEA within that regulatory framework. It also amended the Controlled Substances Act at the same time. So we know Congress was looking at this and had everybody in mind, all three agencies, USDA, FDA, DEA, and it decided to say, you two, USDA and FDA, you're going to regulate this stuff. DEA, stick over here and stick to this stuff, and don't mess with this hemp production business. We've got that under a separate scheme. So our argument is that, look, our district court action is not under the CSA, the Controlled Substances Act, at all. It's under the 2018 Farm Bill. And the point is that under that act, the only legitimate regulators of this stuff are the USDA or possibly the FDA in limited circumstances, and DEA was expressly excluded. And our position is that by forcing us back into the scheme of challenging things under the Controlled Substances Act, we're back on DEA's turf again, which we shouldn't be in the first place. So the district court lawsuit is trying to get a declaratory judgment from a federal court saying the 2018 Farm Bill did X, Y, and Z, and it has these effects. Namely, it cuts DEA out of this loop altogether. So That's what we were going for there. Unfortunately, Judge Boasberg, who, you know, it's not just lip service. He is a very, very intelligent, competent, and good federal judge. You know, he construed our complaint as a collateral attack on the IFR. So it's like we challenged the IFR in the DC circuit, and then he construed what we did in the district court as simply just another challenge to the IFR. That's unfortunate, because if we're stuck just challenging the IFR, we can't get what we believe we're entitled to under federal law and what Congress, and just the plain import of what Congress did in the 2018 Farm Bill, which is, you know, to have the looming threat of DEA enforcement overall operations in this area removed, so that we can, you know, conduct business without, you know, worrying about DEA just suddenly out of nowhere in deciding to enforce the CSA against these in-process materials. And at this point, we have a sort of a suite of options. The DC Circuit action, the petition for review, now that the trial court has ruled, the DC Circuit petition for review can kind of come back to life, and we'll have a briefing schedule, and we'll start challenging the IFR in earnest once that happens. We also have a period of time under the rules to decide whether to appeal or not appeal Judge Boasberg's order dismissing the trial court action. And so we're considering what to do there. And suffice to say that one way to think of these issues is that it's not just about the IFR. It's also about the 2018 Farm Bill. And it's about the boundaries of regulatory power over this important industry, and whether what Congress said in the 2018 Farm Bill is going to have effect going forward. And so we're still considering and discussing what we're going to do next. And as eager as I am to go on even longer to tell you all about that, we should probably keep all of that under wraps. But I guess that the final thing I want to say is that the reason this is so important is the IFR is a big deal for the reasons that Rod ably explained. But so is just the general constant intrusion by a federal law enforcement agency into a business arena that Congress has blessed and regulated separately from the CSA's regime. And those are two kind of related but separate things. And that's why we have two lawsuits going on.
Great. I don't have anything to add to that. I think it, subject to Jody and Ryan's thoughts about how we should proceed, it looks like we've got at least one question, and we're certainly ready, willing, and able to take your other questions out there. So,
yeah, let me go ahead and read that question out so everybody knows what we're all seeing here. So this question comes from Laura. Thanks for your question, by the way. Reading the bill filed by Representative Joyce and Young this week, it would seem that all the THCs off the CSA schedules. Would it, in your opinion, and would it render your case moot or not?
That's a great question. Shane may have some more information than I do. I'm aware of the bill. I was preparing for today and haven't had a chance to read into the details. Certainly that's possible. We have hemp, which is outlined and defined specifically in the 2018 Farm Bill. And then we have separate legislation that's not under the Farm Bill, that's not under, its own legislation that's kind of running in a parallel track. And certainly depending on whether it's enacted, how it's enacted, the language and the regime that's set up, it could certainly impact the hemp industry in certain respects. But certainly for now, and the way that the tracks are running, we have hemp, which is a form of cannabis that's distinct and separate from from marijuana. Both contain THC, but hemp is defined as cannabis with no more than 0.3%. And so that's our understanding now. But it will certainly be interesting to watch legislation unfold over the next 1 to 5 years.
Yeah, I mean, the only thing that I would add to that is you'd have to see how it breaks down, like Rod said, exactly what the language is and exactly what the reaction from various federal agencies and is in the wake of something like that being enacted. However, one thing we do know is just the trend historically, which is that Congress has intervened several times in this area to try to sort of build a fence that would keep DEA focused on the abuse and diversion mission under the CSA and to kind of leave hemp alone, just to put it plainly. And none of those statutes have worked thus far, with the 2018 Farm Bill being the most recent one. And so unless this act amended the 2018 Farm Bill in a pretty significant way, I think chances are the cases would remain live. And of course, you'd have to sort of analyze that through on the petition for review and then the district court action sort of separately. But that's my general sense, is that given the history, there's every reason to believe that DEA would try to find a way.
Agreed.
Thank you both for those thorough answers. We have another question here from Julie, who is asking for the full name and spelling of the judge. Not sure if that is which judge on which case that's referring to.
Yeah, so the judge in the district court case, it's the United States District Court for the District of Columbia, and his name is Jeb Boasberg. And I don't know if Jeb is short for something, but it's J-E-B, and then Boasberg is B-O-A-S-B-E-R-G. And he's not a senior judge, he's an active judge on the DC District Court, a court that I clerked on actually before I came to private practice.
All right, got one more question here. Why don't the regulatory agencies like the FDA and the USDA guard their prerogatives more actively? Why do they give up control to the DEA?
Rod?
That's a great question. And I'll just be straight up and start by saying I don't know. The DEA has exercised a lot of authority and has a lot of power and clout and financial and other resources to begin with. I know that Purdue for the USDA did lament the DEA's intrusions into its regulatory, its own IFR that turned into the final rule, and said the DEA was not happy about hemp legislation. And was constantly trying to push back as hard as it could. I think probably the DEA has a long history with the cannabis plant, and it was essentially the Controlled Substances Act was formed in large measure around making cannabis illegal, or at least marijuana illegal. And it's just kind of part and parcel of its mission. But as to why, it's the behind the scenes or specific policies and positions, I can't answer that. But it's certainly caused us in the hemp world quite a lot of problems.
Yeah, I agree. There's no way to jump into the agency's head, and anything we say would be speculation. I mean, I will say that there are probably a couple of factors sort of, coming into play. These agencies have to work together in this arena and in others. While the 2018 Farm Bill doesn't give DEA authority to regulate or make rules regarding the regulation of hemp, it gives sole authority over that to the USDA. The act does require the USDA to consult the Attorney General, which is the top officer of DOJ, which is the agency in charge of DEA, when implementing certain or promulgating certain rules and regulations. So they have to work together, and it's not just in this area. And so there's part of it is, you know, how much do you want to create a conflict, an interagency conflict, right? And I guess the second thing that I would say is we don't know how much pushback there is going on behind the scenes. It could all be happening behind closed doors. And another thing is that, you know, USDA may say, look, until something happens that starts to actually edge in on our turf concretely, we're gonna keep our powder dry. You know, we certainly don't want to get in the way of a legitimate law enforcement mission that could be happening. And until we know more information, we're gonna stay our hand. It's just too complicated, and there's just not enough information out there to draw those kinds of conclusions. But it is kind of extraordinary that we have public statements from Sonny Perdue and others that, you know, sort of shed a little bit of light on the conflict that was going on when there was a little turf battle in the fallout from the enactment of the 2018 Farm Bill. We know something's, you know, there is some discussion of it, at least.
That's a pretty good segue into our next question, which is, does the new administration in Washington change the likelihood that the DEA will want to fight this fight against hemp extracts?
Yeah, that's a good question as well. I mean, the Biden administration has not been cannabis friendly, you know, broadly speaking, although some parts of the administration have. In some ways, the prior administration was supportive and not supportive. And so I like to think that in the current political environment, that this administration would encourage the DEA, to use a diplomatic term, to route its resources in a way that's really needed and away from hemp, which Congress says shouldn't be regulated by the USDA. And and that kind of, I see the question by Sister Kate, or it's kind of more of a comment about defunding, and I certainly understand that position, but you know, really this is about rerouting resources and priorities into places where they're needed, and certainly taking them out of places where Congress has explicitly said you're not to participate over here. So yeah, hopefully that's helpful. But again, something that we don't know. You know, what's in the minds and behind the scenes.
Yeah, I mean, I don't have a lot to add to that. I mean, my personal view is that, you know, without saying anything about any particular prior acting DEA administrator or attorney general or any of those folks, Merrick Garland, the current attorney general, is someone who I've, you know, I clerked on the court that he was the chief judge of, and he was a very respected judge. And he's just, if you know him and you know his reputation, he is a person particularly committed to transparency and being above board and all of those things. And every public statement he's made, which he is the boss man when it comes in DEA world, and above the boss, you know what I mean? He's above the administrator. He's the head of the chief law enforcement officer of the United States. And he has made very clear that, you know, some of these concerns that are so pressing to us aren't his top priority in a world where he has many other agencies and things and to take care of. And I don't know which way that cuts, but I am slightly optimistic just under his leadership because I personally trust him so much. But, you know, my crystal ball, as I have said before, has proven broken many, many times before. So I could be wrong.
Mine too.
Good insight there. We got one more question here. Has there been any news of local law enforcement taking action against extractors due to the IFR?
That's a good question. I have not heard of any local law enforcement. Local, I'm sort of defining as you know, essentially state oriented, whether it be the SLED in South Carolina or some other SBI in some other state, or local sheriffs or even local police departments or whatnot. I'm not aware of that. I try to stay on top of that through news stories, through clients and Reddit threads that clients will send me and that kind of thing. And I have not, that doesn't mean that it won't happen. And certainly a lot of times what we've seen over the short but illustrious, rise of hemp over the last several years is that a lot of times we'll see these policy statements and rules at a top level, at the federal level, that are not rigorously enforced. And we can think about the FDA and some of its positions on CBD and whatnot. But those positions are enforced in some way, shape, or form by the local authorities. But that's a long way of saying I am not aware of that happening. It could happen at any time, but fortunately it hasn't so far.
Yeah, I'm not aware of anything concrete. I would say that, I've said this before, but now I have a concrete example to give. So my little warning that just because, it's sort of like if you're out on the ocean and, you keep hearing about these sharks, but you don't see a shark and, you feel like taking a swim and I don't see any sharks. People keep talking about sharks. Just because the water is still on the surface when you're sitting there on the boat looking down at the water and there is no enforcement action going on out there on the horizon that anybody can report, does not mean that, the coast is necessarily clear. And I don't mean to drum up alarm. I only mean to say that, just to give an example, I recently read a case that didn't have to do with hemp or CBD or anything, but it was a controlled substances case, and it had to do with someone putting a label saying not intended for human consumption on a product that they actually did intend for human consumption, and they ended up the owners of these stores ended up going to prison for several years for conspiring to defraud the FDA, and behind those charges was a multi-year undercover DEA investigation that was done that you would have never, the water would have looked completely clear there. And I understand we were talking about local, but I just want to say that the fact that we're not seeing the actual visible effects of an enforcement action doesn't mean that evidence isn't being gathered. It doesn't mean that, and certainly business is being chilled, right? And that's one of the unfortunate things about this. So, I just always tell people don't take anything for granted. You gotta, you can be caught off guard. And until we get these things straightened out, we all have to be vigilant.
Yeah, if I could piggyback on that, I completely agree with all that. 2 points to make. One is one of the concerns that I've always had just about a lot of hemp related issues is that, if there's a big, enforcement action by the DEA or some, in some federal capacity, that makes national news and national organizations like the HIA and law firms like Vicente Sederberg and mine and Hoban Law Group and New York Coleman can jump in and get involved or provide our 2 cents or whatnot to kind of help steer things in the right direction. But when it happens at a local level, particularly in the level of a county, maybe a small county in a state, a lot of times that doesn't reach the news, and if the parties involved are not really aware of the subtlety of the issues and the complexities and the arguments that can be employed in that case, then sometimes, first of all, people who are in the hemp industry can end up getting punished because they didn't have the right tools at their disposal, and secondly, we have some bad precedent sometimes that's being set, and that bad precedent being set in a few different cases around the country, even at a smaller level, can begin the tides begin to rise against us. So, I guess my point to all that is if you or people that are aware of some sort of an enforcement action at a local level, I think it's really important to put the word out, contact the HIA. Certainly feel free to reach out to Shane or me. Just in the past couple of days, I got on the horn with a lawyer who was dealing at a local level with another hemp related issue, enforcement, and I just chatted with him, and he had gotten up to speed. He didn't normally do hemp related law, but had done some research and reached out to me, and I was able to provide him with some tools that I thought would be helpful, and that, as it turned out, in that particular instance, they had a good outcome. So I think these things are important. The other piece is more directly related to what Shane said about the DEA and these long-term, undercover and investigations. The DEA partners with local law enforcement in a lot of instances to help, curb drug diversion and that type of thing. And so a lot of times in a local sheriff's office, or you'll have a DEA agent there, and you can imagine that the communications that go on and the positions and policies that are expressed. And so the DEA is able to transmit these policies and perspectives to local law enforcement in that way. And it's important to understand that that does happen.
Something to piggyback on all of this is a comment from Sister Kate. She says, in our case, the sheriff does rip up our fields of hemp, but he does not know or care what's happening in Washington. And Sister Kate is located in California. The sheriff did it before the IFR, after, likely always. They do it when it tests over 0.3%, and it all does.
Well, I'm really sorry to hear that. Unfortunately, the 0.3% Delta 9 THC percentage is pretty low, and it's difficult. Sometimes the farmers are taking a lot of risks now. There's some talk and about potentially raising the THC limits, but right now they are what they are. This is within the purview of the USDA. The USDA has a final rule about this. Most states, including California, also have rules, and so I would certainly. If the sheriff is coming out and acting against the law, well, that needs to be addressed. And so we're certainly happy to maybe give you some thoughts about how that might happen. There's plenty of really excellent counsel, in California who are well versed about this and might be able to take action. So anyway, I'm really sorry to hear that's happening.
Good segue into a question from Randall. If we win our case, can the states override and write their own laws or regulations, either for or against?
The simple answer, Rod, you can correct me if I'm wrong, but there isn't really a simple answer, but I'm going to simplify it somewhat. And basically, yes, the federal law is kind of a floor in this way, and the states are free to a large extent to regulate. Now, the 2018 Farm Bill requires, it is a cooperative federalism regime, so it incorporates the states, and so there's going to be a wider preemptive sphere to that federal law. That said, there are other points of regulation where the states would be able to accomplish enforcement priorities if they had them to some extent without running afoul of the supreme law of the land, which is the federal law. That's about as specific as I think I can probably get answering it.
I'll piggyback. I don't even know why, because I'm not gonna be able to answer any better, but I pause because Shane is he's clerked on multiple courts. He's the expert in these types of nuanced federalism things. But exactly right, this is a federalism thing where we have two different sovereigns, states and the federal government that are regulating and creating laws. And in a lot of cases, states do have authority to raise the bar, so to speak, in terms of what's allowed and what's not allowed. We see that with alcohol, certainly, and I dove into this a couple of years ago pretty deeply with respect to consumer protection laws. Which is, I was actually researching some hemp kind of parallels. And states do have authority, just generally speaking, to regulate the health and welfare of their citizens, and so that gives them a lot of latitude. And there are other ways in which they can do that. So I guess the short answer is, yeah, there are some circumstances in which the states could step in and make things stricter or more tightly regulated than the feds.
And just one last thing, this is it's kind of too much of a complicated subject to give clear answers in a soundbite. So it's a little bit, again, more complicated than what I'm saying. But in general, like Rod said earlier, the federal agencies often rely, and in this arena really do rely, both expressly in statute and in practice across the board, on state cooperation and efforts when it comes to enforcement and so forth. And often there's a sort of reciprocity where the states look to the federal standards and create uniformity on many issues. Okay, so while it is, I answered the question like a law school hypo, an abstract thing, but in reality, generally, most of the time. There are slight variations in state law, especially at times like this when the law is changing and it's in flux, but ordinarily it eventually settles out into a uniform scheme where the federal government is relying on the states and in their arenas, and the states are looking to the federal government to figure out what the standards probably ought to be. We're not there yet because we don't have that much of a worked out scheme. And so that's why we have some instability and confusion, but I suspect in the long run, it will eventually get there.
Thanks for that. We have another question, I think, yeah, from Mandy Weingardner, who is saying that she is a merchant service processor who's been working with growers, extractors, and she's had to decline them due to them providing a concentrate COA because it was an accurate COA. And I believe that this is getting into the banking and how giving properly acquired COAs to your banking can get you into your merchant processor and the business into a little bit of a gray area, and how this is an unfortunate result of the IFR.
It is an unfortunate result. There's a lot of fallout to the DEA's position in general, and as probably everyone that's on this webinar Zoom conference knows or has maybe even experienced personally, merchant processing is difficult to obtain in this industry. And kudos to the merchant processors who are out there. There's not many of you that are really trying to service this industry, because you're participating in a highly regulated environment yourself, trying to service a new industry. And there's these, put in this situation where you have, a statute says this thing and the federal agency says this thing, and the lawyers are saying this and your customers are saying it's difficult. And so I appreciate you sharing that with us. This is certainly, there's a lot of fallout from the IFR, the DEA's position generally. And it's important to express that, and for people to know this isn't just about some random processor in some random state. This is about the whole industry.
I couldn't agree more, Rod and Shane. Thank you both for that. So it looks like we have one last question here from Sister Kate. What can we, the little folks, do to help with the cause?
Support your IHA, that's for sure. Jody can step up with that. But yeah, I commented on this earlier. We're all little folks here, and we're all trying to do the right thing by the hemp industry and by the country, and we all have our roles to play. And so, I would say, what are your resources and what do you do? Is it financial? Great. Finances always help. But even if you don't have financial resources to support these types of things, you know people. You can educate the people around you. Hey, did you know about the IFR? I didn't really quite understand how big a deal this was, and educate them about that, the DEA's position. Or did you know about the lawsuit and what they're doing? This is a crucial time. And then also, certainly to the extent that you have connections with politicians and regulators, educate them about it and let them know that it's important to you. So a lot of things, and I think it just has to do with where you're situated in the industry and what your particular talents and resources and contacts are.
Well said. I mean, the only thing that I would add from my very nerdy federal regulatory view of this whole situation is, the industry, when you're in business in an industry that's regulated, you've got to participate. It's like voting, and you really need to start. There are going to be opportunities for you to comment on proposed rules, to get involved in the process of setting the standards that are going to be governing going forward. And it's very important that you let your voice be heard in that. And, there are ways to organize. And I think maybe the first step is, if you watch something like this, and Rod and I do our best to explain these things, and yet still it's just incredibly confusing, which I know it can be, and it may not make sense. It affects you, and ask us, try to understand what is going on. And if you don't understand, try to reach out to resources like us who we can break it down. We may not have explained it in the most clear way just on this webinar, but we can answer your specific questions, and you need to know what's happening out there, and it is confusing, and there's nothing wrong with asking when you don't know, and then getting involved. How can I get involved? What is the next rulemaking? How do I submit comments to an agency? You know, what are the risks involved in that, and so forth. I think getting that machinery going in the industry is going to be very important going forward.
Agreed. And I think I'll just take this opportunity to wrap things up, because it's a good closing question. You know, Shane and Rod and the organizations that they represent are a prime example of how you can take action and get involved. I mean, the HIA is a trade association that is member-driven, volunteer-led. Everything that we've ever done, all the fights against the DEA, you know, educating the market with Hemp History Week, everything that we've done has been because concerned entrepreneurs and farmers and advocates came together, supported the organization, and pooled their expertise and their passion to make it happen. So if this is an issue that's affecting you, if you think that the HIA is doing the right thing by standing up for the legality of hemp, at a very fundamental level, we do encourage you to just get involved by exploring membership and getting active in laying the groundwork for an industry, a hemp industry that really realizes all of the potential that it can. So that's what we're about. And this has been a great exercise in educating the constituents that we serve, and really want to thank you guys, Rod and Shane, and also Ryan, for your help in making sure that we don't fall on our faces technologically. And most of all, for all of you who showed up today because you care enough about this issue. And once again, I'll echo Rod, please, and Shane, don't hesitate to reach out. info@thehia.org is a general email address where if you have a question, you don't know where to send it there, and we'll get it to somebody who can answer you if we can't ourselves. So,
to learn more about the Hemp Industries Association and to become a member, go to www.thehia.org.